all the viewers to this webinar. I'm a bit of a philologist. I've fallen in love with words and found it difficult to get away from that one. When I saw this particular expression, webinar, I probed. It is a combination of two words, web plus seminar or web-based seminar. It's been condensed into one single word that's become webinar. And there is a word for that expression in technology that's called portmanteau. When you crunch two words like brunch, breakfast and lunch, or motel or smog, what you get is a portmanteau. And here is webinar. Well, thanks to technology, with all its drawbacks, we have got this opportunity to interact. And you're all aware, and I believe you agree with me, that traditionally legal profession is a bit conservative. And we are credited being the last persons to give in to the change. That's why when you think of our legal jargon, we've still been stuck at least 400, 500 years therein, thereto, thereof, and so on. But I don't think we can stop this technology tide or tidal wave. Once, John F. Kennedy has said, "My call to the young, regardless of their age." What he meant was, regardless of their age, once you're young at heart, you can take to the technology because it is for the young people at heart. You know, Richard Susskind, now a professor in Oxford, I think, in 2013, he wrote a book that is Tomorrow's Lawyer, an introduction to a future. And of course, now his latest book in 2013, that's, the 2019, that's Online Courts and the Future of Justice. In his first book, that's Tomorrow's Lawyer, he speaks about some interesting aspects of the technology, how it has invaded the lives. I need not tell that it includes our profession as well. It seems about 4,000 years ago, the Sumerians were credited with the invention of writing. And you could imagine with Gutenberg's machine, printing machine, how much people could have churned out written material. But now think of Google. You know the material that's available under Google. We add every 2 days as much information as it had been there since the dawn of civilization until 2003. That much we replicate in every 2 days. Friends, in 1965, Gordon Moore, the man who founded the Intel, said about the growth of technology. Every 2 years, the processing speed of the computer doubles and the price halves. It halves, goes by half. I don't know how long it's going to, but another expert, Ray Kurzweil, in his book, The Singularity is Near, tells about the speed, the processing speed. He predicted that by 2020, a desktop computer could have the processing speed of our brain. And by 2050, one desktop would equal the processing speed of the whole mankind. Scary to hear and inspiring as well. Now you know pretty well what, in America at least, Watson and Ross, the IBM machines, have been doing to our profession. At least 40% of corporates have dispensed with lawyers and they've been relying on the machines. And in Canada, British Columbia has already started virtual courts and operating them very successfully. To our credit, in Delhi, we have had MACT courts completely unmanned in a sense. And I say this in a couple of minutes because there's been a lot of news around that now with the COVID unending and the lockdown possibly expanding or with partial lifting, we'll be forced to have virtual courts. And perhaps this is the beginning. We may have to. Now let me come to the topic. Friends, I was asked to talk about federalism and judicial understanding. I need not remind you about the scope and the expanse of this topic. Federalism literally permeates the entire fabric of the Constitution. Its sweep is enormous, and I don't think it's possible for me to cover the whole thing in 45 minutes or even an hour. That's why I propose to have a bird's eye view of the topic, and then let's examine a few landmark judgments, how the courts have grappled with this concept of federalism, which has not been, in fact, explicit in the Constitution. To put the issue in perspective, I'll begin with a small story. Friends, I have firmly believed, as an advocate then and as a judge now, advocacy is essentially a matter of storytelling. The more interesting you are, the better you carry the day. I take an instance from Hindu mythology or Puranas, but I'll give it a secular cover. There are two immensely powerful parents. They have two sons, and there is sibling rivalry. Those two sons have been arguing with each other that he is greater than the other. Then the parents wanted to resolve the issue. So they put a test to the children. They said, whoever could fly around the globe, circumnavigate, if I could say, encircle the globe, they would accept that that particular boy is smarter or more powerful. So one of them chose a very swift bird, got onto it, and flew away to cover the world. The other boy, a bit portly built but braining, waited a while, thought deeply, and then went round the parents and told them, I've circled the world because you are my world. Well, it aptly applies, I reckon, to India as a nation, to Indian Constitution as a document, an organic one. Whether you undertake a world tour or that of an Indian, I don't think that makes any difference. You see the ice peaks and deserts, both the places. Then incessant rains and not a drop of rain at one part or another. Desolate stretches and dense rainforests. You come across people of every color and hue, every religion, and almost more than 100 languages with thousands of dialects. India is a microcosmic world with myriad colors and creeds. And do we expect for such a nation a monochromatic constitution? It ought to be colorful, and it is the Indian Constitution. It contains everything. If you think of comparative constitutional perspective, if you study the Indian Constitution, it's as if you had studied all the constitutions in the world. It's a hodgepodge. It's a cornucopia. Once Mark Forsyth, in his book, The Elements of Eloquence, accuses Shakespeare of stealing ideas from people like Plutarch. He says Shakespeare stole, but he stole with style. That's what Indian Constitution did. It has stolen from many constitutions. Let's call it borrowed. And it has adopted that to the Indian conditions. And hardly can we say that it has any foreign element alien to our culture. Take the example of federalism. Perhaps we have modeled ourselves after the American federalism, but we have parallels only in the name, not in the form, by any means. So it is a seemingly conflicting constitution for a nation with seeming contradictions. Now let's see what sets our constitution apart. If you reckon the characteristics of constitution, it can be either written or unwritten. Mostly written though, with a couple of classic examples apart. I need not remind you that UK is the stellar example of unwritten constitution. To a great extent, even New Zealand and Israel qualify for that one. India, on the other hand, is well and truly a written constitution, but it has many constitutional silences, constitutional crevices, and conventions. You take the example of Article 14 or Article 21, there is more unwritten than actually written. That's where the judicial craft has come to play a very vital role. Now, let's have the other character. The constitutions are either legal or political documents. Switzerland and the Netherlands are said to be the political constitutions. That is, the interpreting task falls to the legislature rather than to the judiciary. That's what political constitution, at least going by the scholars. Then, if it's legal, as John Marshall has said, the Chief Justice, it is the judicial department that expounds. Let's take India. I believe it's both. We have accepted, though not fully, the doctrine of political questions or political ticket. And though separation of powers has not been quite explicit, there are certain non-justiciable aspects of the Constitution. There is an interesting discussion on this in the context of Article 356 in State of Rajasthan versus Union of India, that's 1977. Of course, the whole discussion now largely has been rendered academic because of 44th Amendment. But let's see the constitutional provisions themselves. Article 74, Clause 2, that speaks about cabinet advice to the president. It is non-justiciable. Let's take Article 164(1), read with Article 361, that of appointing the Chief Minister and the Cabinet by the Governor. It too enjoys immunity from the judicial scrutiny. To a great extent, I qualify that. Then, take the example of judicially developed aspect, transfer of a judge from one high court to another high court, it's non-justiciable. Then interstate water disputes refer to the Water Dispute Board, again non-justiciable. So Indian Constitution is a happy combination of many things. It can't be cribbed and cracked. Then the constitutions are either vertical or horizontal. When they are vertical, you enforce your fundamental rights against the state or the state actors. When it's horizontal, you enforce them against not only the state players, but also the individuals. If you take, for example, Ireland, Canada, Germany, South Africa, they're supposed to be largely horizontal. Most of the constitutions are vertical. How about the Indian Constitution? Again, I must say, it's both. Take Article 17 on abolishing untouchability. It applies across the board horizontally. Take Article 23, prohibition of human traffic and forced labor. It again applies across the board. Article 24, child labor, so is the case. To some extent, the constitutional torts too qualify. And I may mention another aspect or facet to this one, the indirect horizontality. We compel the state to do something, but it rebounds on an individual, so that we get a constitutional protection vis-a-vis an individual. In the Indian context, the best examples are Geeta Hariharan's case versus RBI and also Vishaka versus State of Rajasthan. If you want a classic example of this indirect horizontality, that's of New York Times versus Sullivan, where First Amendment protection was given vis-a-vis an individual. That's why we have accepted the state action doctrine as well. Now, the last distinguishing feature for a constitution, I may say, a constitution can be either unitary or federal. On this question, at least until S.R. Bombay, the debate had raised on. Many a constitutional bench, many a larger bench of 7 judges or so, has debated this issue unendingly. Then what's the right word to describe the Indian Constitution? Once Mark Twain has said, if I can quote, the difference between the almost right word and the right word, almost the right word and the right word, is really a large matter. It's the difference between the lightning bug and the lightning, a firefly and the actual lightning. And we are very fond of labels. Let's see how the Indian Constitution has been described, either by the courts or by the scholars. It's been described as quasi-federalism, marginal federalism, fictional federalism, compromised federalism, effective federalism, loose federalism, pseudo-federalism, amphibian federalism, cooperative federalism, federalism by aggregation, a federation with a strong centralizing tendency, a unitary state with federal features, essentially unitary, a semi-hegemonic federal structure tilting in center's favor, but Very few have emphatically said it's federalism per se. I call it, if I take the liberty, the pigeonhole theory. We're all xenophobic in the sense we're afraid of new things. So when we come across something new, we have already built mental attics and there are prefabricated pigeonholes. So we take this new thing and try to put into one pigeonhole. One or another. If it doesn't fit into any pigeonhole, we tend to reject it. We feel it heretical, sort of a maverick method, unconforming. And the mental pigeonhole all the scholars initially had was the American model of federalism. That was a pigeonhole. So we always tried to fit this into that one and found that it wouldn't. So the confusion, the contradiction. What we have initially forgotten is federalism is a matter of functional approach rather than institutional. We may have to think of that in the organization point of view. Now let's see how it has come about across the world and how it has percolated or come down to the Indian political scenario. Initially, there were nations, peoples as we could call, with distinct tribalistic identities. They are homogeneous. Then came monarchical system of ruling. But later, the geographical compulsions, the survival compulsions, racial affinities, linguistic links have led most of these nations to come together as confederations. And it was usually through written instruments though. Later, those confederations matured into unions. Let's take the classical example of the USA. Initially in 1781, 13 states of North America formed a confederation. Then in 1787, they agreed to have a union, but not unification. It started to be functional from 1789 onwards. Later, many other nations have followed suit. For example, Canada, Switzerland, Australia, now defunct USSR, Germany, India, Malaysia, Nigeria, and so on and so forth. For all these nations, USA is the model or the prototype. But let's remind ourselves, there is no agreed definition for federalism or what's meant by a federal state. It's a matter of degree. How many federal features a polity possesses, that matters. We cannot miss the woods for the sake of trees. Friends, when it comes to the distinction, essentially there are three types. As I've already said, the unitary state, then the confederation, and the federal state. And federal state stands between the two extremes, that of unitary and the confederate. In a unitary state, as we all know, the power stands vested in a single central government with no constitutional limitations, at least theoretically. parliamentary supremacy is acknowledged, and no constitutional limitations on the sovereign legislative functions. Of course, there are local governments, but they are the agents, and they function on the principle of devolution rather than division of powers. And most importantly, there can be no judicial invalidation of legislation, no judicial review of the legislative powers. Now let's think of the Confederation. It's a loose association of independent states which create a union or a central government only for certain limited purposes, such as defense, quite an obvious one. The central government would not have any direct authority over the people. Only the constituent elements would have. This confederation owes its existence to a compact or a contract. It is a matter of plurality of sovereign states. That's what America was between 1781 and 89. But federalism is a matter of political culture and political maturity. Even after USA becoming a federal state, to begin with 13 states, this federal spirit has not sunk in them. They just behaved as if they were still a federation. They started with mutual distrust, competing with one another and trying to outsmart one another. Then there was a virtual division of South and North, slavery being the catalyst or the trigger point that led to a civil war which lasted between 1860 and 65 and took away president as well, the most popular one. That was attributed by the scholars to the lack of federal spirit on the part of the combining states. That said, I must also note that a federal state is a union of several states. It is union, but not uniformity. Rather, unity. It's uniformity, but not monopoly. It derives its authority from a common source called the Constitution, a written one at that one. This Constitution divides powers, and those powers cannot be withdrawn or curtailed. Nor is the distribution altered. A dual government quite obviously comes into existence. One government is not dependent on the will of the other. And in fact, the federal constitution operates as the supreme law for the entire country. Now, what's the nomenclature we could give? Is federalism a singular concept, indivisible? Or can we have shades of federalism, as India professes? So after all, we need a name. We can as well brush aside by quoting perhaps Shakespeare in Romeo and Juliet, that which we call a rose by any name would smell as sweet. But constitutional labeling cannot be decisive. Take the example, quite a curious one. Neither the Indian Constitution nor the American Constitution use the expression democracy. They are nonetheless vibrantly democratic. The word federal or federation is not to be found in the US Constitution, but that's supposed to be the pinnacle or the picture perfect or classical style of federation. Then India uses the expression federalism, rather federal, if not federalism. I stand corrected. It says, or that uses as an adjective before court. It says federal court, federal court, federal court in the context of the Supreme Court. And it may not be out of place if I could remind you that there may be any amount of discussion, doubt of whatever nature when it comes to this taxonomy of classification. What sort of legislature we have, what sort of legislature we have. But there's no doubt that all along, judiciary in Indian context, in Indian constitution, is unitary. Now, let me briefly focus on federal features that animate, that imbibe any federal constitution. There is no agency. Neither government acts as the agent of the other. To put it simply, a state government is not the agent of the central government in any federal system across the globe. There's no subordination, only coordination. Indeed, even in unitary system, we have discussed that there could be local governments and municipalities, but they are the government's agents with devolution of power. But in federal polity, there is a three-tier administration. The apex, or rather a co-equal central government, then the state government, and below them comes the local government, but not being a legal entity as such, in the constitutional perspective, not the statutory. There is a legally enforceable division of powers. As federal and regional by the written constitution. The authority to interpret the constitution and the laws lies with the court. It is indeed a unity with multiplicity, nationalism with localism. No doubt it's appropriate for larger countries or countries with myriad variations, such as India. It epitomizes the sharing of power among different entities, at least between two entities. As you know, the American and Australian constitutions have this enumeration of powers with the states holding the residuary powers. After all, power matters. But Canada and India, on the converse, have the center or the federal government, or the federal legislation, having the residuary powers. If I could enumerate the typical features, it's a union of autonomous units with a dual government, both having direct authority over the people of both governments, possessing a written constitution, a rigid one at that, having supremacy of the constitution at its core, with the authority of courts to interpret. It's emphatically the province and duty of the judicial department to say what the law is. If I could quote, as I was referring to earlier, John Marshall, Chief Justice John Marshall, in Marbury versus Madison. It is for the court to enforce the division of powers as well. And importantly, there is perpetuity and indissolubility. I mean, the Constitution does not permit states unilaterally secede from the Union. Even at the height of the Civil War, certain states, southern states, especially in US, withdrew. Later, they rejoined. Then, there arose a question. Was there any hiatus, any gap in Texas versus White in 1869? The American Supreme Court has emphatically held that there is no secession, and whatever departure on the part of Texas was an aberration and void ab initio. And another feature that I could recount is fixed legislative fields, as we could witness from Articles 245 to 254, read with Schedule 7 of our Constitution. Both the Union and the states have their own legal personalities. They have shared sovereignty. It's a sort of pluralistic theory of sovereignty. And the judicial review, to be specific, the doctrine of unconstitutionality plays a role. And we interchangeably use both expressions of unconstitutionality and ultra vires. But I've come across an interesting distinction made by Durgadas Basu, the acknowledged master of the constitutional law. He says, if any legislative act in adopting the powers granted by the Constitution, the constituent powers, transgresses its limits, then it is a matter of unconstitutionality. On the other hand, any authority transgresses a statutory power, it's ultra vires. To put it prettily, I may say, whatever transgresses the constitutional power or constituent power, it's unconstitutional. And whatever transgresses the statutory power, it's ultra vires. It's only of academic interest, I felt, nothing more. Now let's move on so that we could wrap it up and come to the next aspect. How are the federal states formed? They could be either by voluntary agreement, as was the case with USA and Australia, or transformation, that's the case with India and Canada as well. We know pretty well that India was substantially a unitary state until 1935. With the Government of India Act, it has come to be a federal, and that was imported into our present constitution as well. As Article 1 of our constitution declares, India shall be a union of states. But there is a historical twist. If you notice, in the Objectives Resolution in January 1947, it was decided that the residuary legislative powers must vest with the states. Then came the decision to divide India, partition. That decision was in June 1947. That followed a communal cauldron. So under these changed circumstances, the Objectives Resolution decided that the residuary powers must lie with the Union as Article 248 mandates. Because then the framers have felt that they needed a stronger center to hold things together. Many people feel that how could India be federal when we look at Articles 3 and 4? And such a feature is unheard of in other constitutional domains, including Canada, which almost travels along with us on federal principles. The central legislature, the parliament, can alter the boundaries, even obliterate the state. Though we could think of the essential constitutional provisions as to how the Constitution operates in the federal sphere, especially that of emergency, then the cooperative aspects of federalism, and the delegation of legislation, and the whole gamut of center-state interaction. I reckon we have only been left with a 15 more minute time before I could as well have a bit of discussion on whatever we have discussed or we're discussing. Now let me focus on how this complex instrument has been read in the decades beginning from 1950s to this day by the courts, especially the apex court. I may begin here, if you permit me, a couple of sentences from a judgment or two I may have to read out, then I'll be running through the other gist. I come across the earliest one on this federal concept, expounded or expanded or explained, is Roy Sohab Ram Jawai Kapoor, the textbook case. State of Punjab, AR 1955, SC 549. I need not refer to them as well. In that one, Chief Justice Mukherjee has said, our constitution, though federal in structure, is modeled on the British parliamentary system. Now let's come to Atiabari Tea Company versus State of Assam of 1961. It deals with the taxing power and the interplay between Part 12 and Part 3 of the Constitution, dealing with finance, trade, etc. In that one, P.B. Gajendra Gadkar, Justice, as his lordship then was, speaking for the majority, he said, it's a federal constitution which we are interpreting. And so the impact of Article 301 must be judged accordingly. Interestingly, Chief Justice B.P. Sinha was a part of the bench and rendered, I believe, a minority judgment. But he did not join the issue on this aspect. Later, in more than one judgment, his lordship has taken a different stand. We'll examine that. In automobile transport versus State of Rajasthan, that of 1962, a 7-judge bench, the majority speaking through Justice S.K. Das, as his lordship then was, reminds us that the Constitution itself says by Article 1 that India is a union of states, and in interpreting the Constitution, one must keep in view the essential structure of a federal or quasi-federal constitution. But throughout the judgment, he kept on using the expressions federal and quasi-federal simultaneously. Of course, there comes a dissenting judgment in that one. If I can use the expression with liberty, the eternal dissenter of those days, none other than Justice K. Kokasubarao, as his lordship then was. Our Constitution provides, his lordship says, for a federal structure with a bias towards a central government, but real and substantial autonomy was conferred on the states within the boundaries of the fields chalked out for them. It rings true for the future, in fact, as all dissenting judgments would have it. Then comes a very crucial one, West Bengal versus Union of India. It's of 1963. If you come across any commentary in any form by the author, the learned author Durgadas Basu, he has to his credit dedicated hundreds of pages to this judgment. And it was by a 6-judge bench. I reckon it's a unanimous judgment by Chief Justice P.P. Sinha. It concerns the acquisition of coal-bearing lands of West Bengal by the Union government. Then that was taken to Supreme Court. Yes, there are other voices as well. I stand corrected, it's not a majority one. Here, the 7-judge bench has said, there is no warrant for the assumption that the provinces were sovereign, autonomous units. It was not in tune with the earlier pronouncements though. Then it goes on to explain, there is undoubtedly distribution of powers between the union and the states in matters legislative and executive. But distribution of powers is not always an index of political sovereignty. Then it has said, legal sovereignty of the Indian nation is vested in the people of India. You may kindly pay a little bit attention to this articulation. Legal sovereignty of the Indian nation is vested in the people of India, and the political sovereignty is distributed between the Union of India and the states with greater weightage in favor of the Union. Now kindly see the dissenting judgment again by Justice K. Subbarao. The political sovereignty of the country rests in the people of India. On the converse, the legal sovereignty is divided between the Union and the different states, and His Lordship calls them the constitutional entities. According to him, under the scheme of our Constitution, sovereign powers are distributed between the Union and the states within the spheres allotted to them, though the states are bound by the territorial limits. Here, it's been clearly articulated, the shared sovereignty concept. According to him, further, nor the emergency powers which subsume the state's legislative and administrative domain could detract from the federal nature of our Constitution. Now let me come to another 7-judge bench decision. That's in 1965. This is that famous parliamentary privileges case that's come from Allahabad, rather UP Assembly. It's one of its kind, and I may, as an aside, tell one interesting aspect. And this one, the UP government advanced an argument in the absence of any codified law on parliamentary privileges. We tend to follow the Westminster system. We are all aware of that one. Then, when it comes to contempt of the House, the state has argued that it's non-justiciable, and it has quoted an English decision where the House of Lords has held that the contempt of Parliament there is non-justiciable. But the Supreme Court, in this reference matter under Article 143, has held that decision involves the contempt of House of Lords itself, a part of Parliament, but also a court by itself. In India, there is a clear dichotomy. That's why principle cannot be imported. At any rate, the Supreme Court has held the essential characteristic of federalism is the distribution of limited executive, legislative, and judicial authority among bodies which are coordinate and independent of each other. It is also stressed that the supremacy of the Constitution is fundamental to the existence of a federal state. Thus, the dominant characteristic of the British Constitution cannot be claimed by a federal constitution like ours. That's what matters for us. It's been underlined there. And next comes Keshwananda Bharati of 1973. And it says, though not in single voice, the Constitution has all the essential elements of a federal structure, as was the case in the Government of India Act 1935. The essence of federalism being the distribution of powers between the federation or the union and the state or the provinces. Here, there is a very interesting observation. It is noted, Article 368 has given more protective measures, taken rather more protective measures vis-a-vis the federal features of the Constitution rather than Part 3, the fundamental rights. In the words of their lordships, let me say, the prescription of a more rigid procedure for changing the provisions specified in proviso to Article 368 underscores the fact that the framers of the Constitution regarded them as more valuable than the provisions of Part 3. They attached more value to federalism than to the fundamental rights. Now, I may rush through a little bit. Then comes Shamsher Singh versus State of Punjab of 1974. Chief Justice A.N. Ray said, the expressions union and state occur in Articles 53(1) and 154(1), respectively, to bring about the federal principles embodied in the Constitution. Of course, there's a concurring judgment by Justice Krishnaiyer. It also gives an interesting read, as he refers ours as Indo-Anglican version of the Westminster model with quasi-federal adaptations, historical modifications, geopolitical mutations, and homespun traditions. It's a typical Attic style, as scholars could call it. Now let me come to State of Rajasthan versus Union of India. That's in 1977. Chief Justice Beg authored the lead judgment in that one. And I believe it has taken a step backward, and it has held, in a sense, therefore, the Indian Union is federal, but the extent of federalism in it is largely watered down by the needs of progress and development of a country which has to be nationally integrated, politically and economically coordinated, and socially, intellectually, and spiritually uplifted. To that extent, perfectly in sync with the previous judgments. Then it quotes Dr. Ambedkar to hold that though it has dual polity, it has avoided the tight mold of federalism in which the American Constitution was forged. It also stresses that the Constitution is both unitary as well as federal according to the requirements of time and circumstances. Then it calls the central government amphibian. It can move either on the federal or unitary plane according to the needs of the situation and circumstance of the case. Now may I refer to Sankar Chand, that's of 1977. Justice Y.V. Chandrachud, as his lordship then was, in the context of the independence of judiciary, has said, independence of a high court judge is the highest public interest, particularly in a federal or quasi-federal constitution like ours. And if there is a conflict of interest, the high principle of the independence of the judiciary must prevail. Then comes State of Karnataka versus Union of India, again a 7-judge bench. In that, Chief Justice Beg called it pragmatic federalism. Then, though it has quoted Keshwananda Bharati, it says the so-called federalism as a fetter on legislative power must find expression in some express provision to be recognized by courts. It may be mentioned here that a majority of judges who decided Keshwananda Bharati case have not treated federalism as part of the basic structure of the Constitution. And none of them had discussed the extent of the federal part of the structure. The Constitution itself does not use the word federation at all. That's the opinion of the 7-judge bench in state of Karnataka versus Union of India. Again, perhaps not in sync. The lone minority is that of by Justice Kailasam. Echoing what would be coming later in a survey. In the distribution of powers, there is a strong tilt in favor of union. But the union government cannot claim any power which is not vested in it under the Constitution. There's no overriding power with the union government. It cannot deal with the state government as its delegate. But the source of power for the union as well as the state, which is the Constitution, and the union government cannot claim any powers of the state which are not found in the Constitution. Now, later followed Pradeep Jain, a 3-judge bench. It said India is not a federal state in the traditional mode. It has certainly and undoubtedly has certain federal features, but still not a federal state. Perhaps it's been guided on the concept of single citizenship, as India's case, contrary to the American. Now, finally, I'll come to Mr. Bombay before I sign off. Friends, it is the watermark in the federal adjudication. A 9-judge bench has rendered, I think 5 of them rendered their opinion. It's been emphatically said federalism is a basic feature of the Constitution. They've accepted it is a pragmatic federalism. It's a concept which unites separate states into union without sacrificing their own fundamental political integrity. Of course, throughout the judgment, it's been echoed by all the judges uniformly. Thereafter, there have been a handful of judgments on this topic, but they have largely followed S.R. Bombay. I believe, beginning with Chief Justice Gajendra Gadkar in that presidential reference, and capping that with S.R. Bombay, the Supreme Court has always accepted India to be a federal polity, but it has served certain caveats with the expressions like semi, quasi, etc. But the fact remains that it is robustly federal. And that's been reflected even in Rajmanar and Sarkaria commissions too. So was the articulation by Dr. Ambedkar, who said the Indian Constitution would work as a federal system in normal times, but in times of emergency, it could be worked as though it were a unitary system. It is truly an amphibian system. And perhaps, until further cogitation by the Supreme Court, S.R. Bombay holds the field. And perhaps it's time we had our discussion, if possible.
Thank you, sir. There are some questions which have come in, which, if you allow us, we would like to put to you.
Yes, please.
Sir, one of the one theme that we're seeing in the questions is the bias that the Indian Constitution has towards the central government, which you also pointed out from Justice Subbarao's judgment.
Yes.
Now, in case of a constitution which is often referred to as quasi-federal constitution or a compromise federal constitution,
yes,
what are the characteristics which make this constitution more federal than unitary?
Well, good question indeed to begin with. Initially, the whole problem is with the labeling. Something like more federal, less federal, or more unitary or less unitary. Because being federal or unitary are not typecasts, rigid modes. They are functional parameters to be applied to them. Initially, the constitutional framers, in their statement, as I was referring to, January 1947, felt that it should be absolutely on the US model, completely federal, a classic mold, and they felt that only 3 powers, enumerated powers, could be given to the center, such as defense and other things. The rest should be lying with the states. There are 2 factors for that one. Sizable population of Muslims have had their reservations about the majority intentions. Then there have been many principalities outside the fold. They were edgy to come into the fold. So to assuage their fears, to allay their apprehensions, the framers have felt that there should be a perfect federal model. Then came the partition, then came the communal disturbances. And with the division of state, the framers have felt, after all, any product, be it constitution, is the product of the times. Perhaps in peaceful times it could have been a different constitution. That's why some people say the originalism should be discarded when it comes to interpretation. A provision must have been framed and applied at the time when the situation demanded. Down the line it may have its contours changed, still hanging on to that may not be right. But here, history has contributed. Later, the sheer heterogeneity of India has contributed. And that's why in India, in many respects, unique, and the constitution has not conformed to any particular mold or model. Only with back formation or hindsight, we have been labeling it. That's why it has not used any label as well in the constitution. It has found a system, whatever is useful for it, and it is applied. Later, we have been giving names to them. And that depends on our political view and which school of political philosophy we subscribe to call it unitary, federal, or federal dominated by unitary, and vice versa. Yes, please.
Sir, I would ask you a follow-up question, which it's a separate question, but I think it would be a good follow-up to what you just discussed.
Yes.
In your opinion, has the contemporary constitution as we see it today lived up to the intentions of the framers in the context of federalism?
Mr. Abhay, could you repeat that question?
I'm sorry, I said, has the contemporary constitution in its form as we see it today lived up to the idea of federalism as propounded by the framers of the constitution?
Yes. The present constitution. You know, our legal profession, we weigh words. We weigh them in scales, semantic scales, and we deal in them. That's our trade, of course. If you watch Andrew Burroughs' recent Hamlin lecture on interpretation of statutes, it's come out in the book form as well and available in YouTube. Anybody interested to read, rather watch. He says, any statute, more so a constitution, is always current. The now and present philosophy applies to it. A constitution, say for example American of 1787, must be treated as if it were made the other day for applying it. So is the case. Indian constitution could have been made in 1947. For all purposes, it's been as if it were the yesterday's constitution we are applying. Now and present, it's come into existence. Well, the framers have expected that the Indian polity must be functioning as robustly democratic with a republic culture, and then having federalism at its core, at the same time having a very strong center to sink the regional disparities and to emerge as a strong nation with one identity. Perhaps that could be the vision of the constitutional makers. And I believe India has done that tremendously well. More particularly, if you want to estimate or assess your success, you must have had a certain space to compare that with, some standard. And you've seen what has happened in the Asian region, our neighbors, etc., how constitutions have collapsed. And India is a stellar example. Even the most optimistic Western political philosopher, an Oriental watcher, has never thought in his wildest dreams that India could be this much successful as a democracy with all its inherent, inevitable contradictions. Yes, I think India has passed the test. The framers have visualized with a distinction and more.
Thank you. Thank you, sir. We are running a little short on time, so I will have to...
Thank you very much. Perhaps I've had a couple of stories. I could have cut them short. But anyway,
no, not at all.
The temptation of having stories. Thank you very much.
Time these days is the only resource that we have in abundance, sir.
Indeed.
This is a topic which is of immense constitutional and in certain ways, although taking your hint, certain ways also political importance. As lawyers, I think we are first and foremost students of the Constitution.
All of us.
But we often tend to avoid studying it because of how intimidating it is.
Yes.
But this lecture has given all of us an overview of this subject of federalism. Speaking for myself, it has certainly made it a lot less intimidating. And now that you have shepherded us through the jurisprudence relating to it, I think we can use the time that we have to educate ourselves about the topic. Let me thank you for agreeing to come on to our platform again and delivering this lecture, sir. Thank you very much.
Starting off, let me tell one thing. You said that Constitution is intimidating. For young lawyers, I would like to say, let's always have the incremental approach. I always question young lawyers and tell them, how much time will it take to count on a clear night sky all the stars,
right,
one after another? People will say 10 years, 50 years, lifetime, impossible. A mathematician has said it takes only 3.5 years. That's the power of incremental approach, a page a day, whatever, you're conquering the Constitution. Thank you.
Thank you, sir. Very sound advice. For all our attendees, I would just like to let you know that our next webinar will be an interview of Mr. Sanjay Hegde, who is a senior advocate practicing in the Supreme Court. He will be interviewed by Mr. Pranjal Kishore, who is his junior and is now an independent practitioner in the Supreme Court and the Delhi High Court. This, as we have done in the past, will be a break from our academic webinars and will give you all a practical insight into the life of a senior advocate. As far as this webinar is concerned, we will publish it on our YouTube channel soon. Please subscribe to it. And please also follow us on our social media pages to remain updated on all our future events. Thank you very much. I hope all of you stay safe in all these times. Thank you, sir.